Well, my own feeling is as soon as you see bankruptcy looming on the horizon, you should retain counsel. And there are several reasons for that. Perhaps the most important is your case may require some pre-bankruptcy planning because if you file an emergency case and you haven't done that pre-bankruptcy planning, there can be some very serious consequences. I'll give you just a couple of examples. Let's say a business has an ongoing relationship with vendors and pays a vendor something like $20,000 for something because of an antecedent debt, and then files a bankruptcy case shortly after, let's say under Chapter 11. Well, that payment can constitute what's called a preference or a preferential transfer that will be undone. And you can avoid that problem by waiting a while so that enough time has passed so it's no longer what's called an avoidable transfer. But if you haven't retained counsel and done that pre-bankruptcy planning, well, that vendor is probably going to stop doing business with you, because after having to give that money back, they're probably not going to view you as a good risk at all, and there may be bad feeling, bad blood there. So you want to make sure that you retain counsel ahead of time. Also, there may be, within the context of a personal bankruptcy, questions about exempting assets. And if you don't do some careful pre-bankruptcy planning, depending on which chapter you file, you may end up losing assets, or it may go into your plan of reorganization and force you to pay more than you otherwise might have needed to pay. So my feeling is, yes, you really should retain counsel right away. In fact, there may even be some non-bankruptcy solutions that you can pursue that would avoid bankruptcy altogether, but you're not going to know that unless you have a good attorney to represent you. So if you see that you've got some problems, call. And sometimes I will have people call. In fact, there's a business down in Long Beach that I've been in touch with, and they've had some difficulties with a particular lender, a quasi-criminal lender. The euphemism that's used is a hard money lender, but this is really almost at the level of Don Corleone. And so we've had a number of consultations and mapped out a course of action. If we hadn't done that, well, this business might have just burst into flames if we'd gotten to the point where they called and said, we need to file a bankruptcy right away. Also, there may be a need to gather information and documentation. Sometimes that takes a lot of time. And so to call an attorney and say, you know, I've got to file bankruptcy tomorrow, generally speaking, I won't even take a case like that, because I figure if the person has waited to the last minute, that person's probably never going to get me the necessary documentation and information to cure whatever filing deficiency there is. So in sum, yes, contact an attorney right away if you see that you've got a financial difficulty, and let's see if we can't fix things or at least plan for a bankruptcy if that's necessary.